So good morning, everybody. Thank you for joining me with this presentation. So for background, my name is Bao Tran. I used to be a patent lawyer, but I don't miss the law firm days anymore. So I got a long way of gotten to here. I was a chip designer, and then I went to the business school at Columbia. And then my mother had an illness, so I went back to take care of her, and then I had extra time on my hands, so I had the law degree. Figured I was going to go to corporate law. But I came out and they pushed me into patent. So I architected some of the first compact patents with the legible, back in 97 time frame. And then Fish moved me to California, and then one of the startups that I was working with was back then a two-person startup, Invisalign Technology. And so at the end of the year, I was about to jump to another law firm, and then the line said, "No, you're not going. You're coming over here and taking some stock." So I didn't know what stock was at the time, but I figured, well, what the heck, we'll try it. And of course, that was in December of '99, and everybody was going to .com. And so they laughed at me for joining a medical company. But as luck had it, within a few months, the .com crash came, and I would look around, I'm the only one left. So that's a little bit of a history. After Invisalign, then I went out and I helped a bunch of other startup companies, and that's really the precursor to Transformation Ventures. And of course, with my IP background, I had a lot of requests for help in terms of monetizing. And so that's the genesis of this. So, as you heard the 8 o'clock session today, licensing technology office is becoming one of the revenue drivers for the school. And so, with the federal funding cuts, the university are turning to the patent side of it for getting more resources to the universities. And so, I work with a lot of startups, and they have a tiny fraction comparing to what the universities have. And so I hope that what we've learned in working with startups might be transferred to your size of portfolio. So for the startups that we work with, they always say, well, what is why should we file patents? Well, for medical device companies, that's a no-brainer. They train from day one to do patent first and then ask questions later. For a lot of software companies, I work with a bunch of blockchain companies, and they were open source, and they weren't really that enthusiastic about patents. But as experts, you guys are expert in the patent side of it, in the license side of it, you need a patent portfolio. So fast forward to maybe last year, AI is also having these moments of whether or not we should be open source, where should we patent, and this and that. And so we've helped a number of companies build a portfolio and then ensuring their exclusivity out of it. So, of course, the slide here states the obvious. The strategic licensing generates recurring revenue, and it aids in the research. The portfolio valuation informs the licensing and the investment decisions. And then most importantly, it's data-driven assessment that would help you. As Michelle this morning said, that her licensing her approach to companies are now, based on her experience, shifting from the late stage toward the early stage, right? So we think, or at least in what we do, is we start off working on a patent portfolio at the very beginning, where we try to assess, when we work with law firms, we say, well, your claims are very good right now, but when you enforce it, what market is it impacting? So, our kind of recommendation of the path is in alignment with what you heard this morning, which is start at the beginning, work with the professors, and figure out, okay, this is your core technology, but where else could we deploy that? And that determination of where else you can deploy that will affect the value of your patent portfolio significantly. So here's the IP monetization cycle and the firm that the company that we use. So first, we capture the research from the startup companies and then transform them into high quality patent applications. Of course, all law firms, they claim they do the high quality patent application, but I think we need to stretch them a little bit more. You need to ask them, okay, these claims are good, but who potentially could infringe this? Where could we go to get money from this? And what proof do we have that your proposed claim will address these industry? And so I think that you used to ask when the patent issue, but it's becoming more important to now move that earlier and earlier in the cycle. For example, even at invention disclosure. This methodology also applies when you prosecute the patent. You need to ask your law firms, when they send you a proposed response to an office action, what words in your proposed amendment will kill off half of my market? You need to do that analysis as early as you can in the cycle, because if you wait until the patent issue, it's too late to do anything about it, right? And you need to keep this evaluation an ongoing thing. You don't just wait until the patent issues to do the evaluation. Of course, if you do if you as a university performs this diligence at the time when the patent issues, you know you've gotten something that that's worth something versus just a patent that covers a very narrow space of research that nobody's, that in fact, probably most of you are doing right now is you're trying to chase a lot of companies trying to get the license, but nobody wants it. So I think we need to invert the IP capture process. Don't wait till the end. Move all the way to the beginning, because that's where you can affect the most relevant changes to the direction of the portfolio. So universities typically don't, the tech transfer offices, they typically don't deal with the IP, they just throw it out to the law firms. I would pose that that's the wrong way to think about it. Why? Number one, if you let somebody else do the thinking for you, you've lost control of it. You're just ending up paying a lot of money for something that might be novel, but it might not be commercially relevant, right? So in our startup that we work with, we use a tool that basically takes their research before they publish and turn that into a patent application. There's debate. AI may be good, may be bad, may be hallucination. There are all those debates, but the way we do it is relatively safe. We take the publication, we convert it into a full-blown application using AI, and then we attach the paper at the end. And then we file that as a full provisional. No harm done, right? And the cost of this is going to be dirt cheap comparing to hiring a firm to convert a provisional into a full-blown application. So using this process, what we've done is we've distilled the paper into a reasonable provisional. I'm sure a lawyer reviewing it is going to improve it some more, but at least you've gotten a framework in place. And you've done this cheaply enough that, so a year from now, you find out that there isn't, a next move. It's not gonna kill you. You can use that time frame to focus on whether or not these patents, the provisional application should be converted. And if you choose to convert those into a non-provisional, you can go and tell your counsel, hey, we've gotten, a decent draft. Let's say a C grade or a B grade draft. I want you to just go in there and tune it up to an A grade. That cost of conversion is going to be significantly cheaper than to have somebody write it up from scratch. So what we propose is not so much getting rid of the lawyer. I'm a lawyer, but use that as a co-pilot to aid the lawyer in the process of number one, drafting the application quickly. Number two, use that to fine-tune the claim and analyze it to see if these claims actually cover somebody useful. Because my guess is in your portfolio, probably half of it is not assertable, right? So if you use this targeting methodology up front, you're going to come up with a higher quality patent and one that might bring you, optimize the cost ratio. So in 2025, you walk out into the exhibit area, you're going to see at least 4 or 5 different firms. AI patent drafting is now becoming well accepted. So that's at the present. They are acting as co-pilot to the lawyers. I think in 2026, we're going to demo a new software by one of the companies that is going to try and take your PDF of the paper of the professor's write-up and convert that into a provisional, and that's going to start saving you money. And then I think in the future, you're going to see is a seamless flow of disclosure to prosecution to patent, and all of these, you can start your licensing activities early because now you have a target on early. So the result is better quality assessment, faster prosecution timeline because it's now very targeted. A lot of time, patents, even though they're narrow, they can be commercially extremely valuable. So let me give you an example. I was, I think, in that journey of Invisalign, they had all sorts of fancy technology. They had dental scanning technology. They had dental CAD modeling technology so that you can move your teeth. And then to transfer that into a physical model, Align at the time had the largest 3D printing technology in the world. They had like $20 million worth of equipment back in 99 time frame. And at the time, that was unheard of. They were the biggest customer of 3D printing, right? So they had all this fancy technology, and they were coming up with a new product that the orthodontists were both they love and they were scared of. They love it because it's technology that's the future. They're scared of it because they know that if they made it so easy that the dentists could end up doing it to get rid of them. And fast forward 20 years, that fear became, I went to my dentist and she's offering Invisalign. So, but that's just the road of technology, right? The way you think about this is, like then we were looking at this and he says, oh, of course we're going to patent 3D printing. Of course we're going to patent dental intraoral scanning technology. Of course we're going to patent the CAD tools that were moving the teeth. But all those, what is the most valuable thing? The most valuable thing to turn out is that we want to block the way people cannot add an indicia to the alignments, the retainers. Because no matter how you do it, you could do it manually, but if you can't sequence it, the treatment is useless, right? And so in fact, that anticipated a competitor, I forgot the name, but they came out with a product called red, white, and blue retainers. Well, they got blocked very quickly after that. So what you gotta do is think strategically in the patenting, not just blindly patent the actual how it works, but think about how it's used. So that's kind of what we here is the objective assessment. Is you look at the claim breadth, you look at citation analysis to see what area, how that area is evolving, how specific the technology is. You also have to consider international filing. So when I was there, my convention with them was, heck, why would you want to patent in Saudi Arabia? And the founder, Ziajisti, overrode me. He says, no, go everywhere. And back in the year 99, going global was costing $250,000. Now it's probably $2 million, right? And I got overridden, but I think he was right in the end. Invisalign turned out to be a global product. So that was, so that was a lesson to me. But of course, that's the exception, right? How many companies are Invisaligns? So again, here you analyze the strength, the legal strength, as well as the technical strength, and then most importantly, to me, the economic strength. It's not so much that you're getting a patent for a patent's sake. You are getting a patent for valuation, right? So how do you value the patent? So there, of course, are a number of ways you can value them. You can value them based on how much you put into the development of the technology, plus the cost of patenting, which is going to be cheap. That's a market method, which is how other patents have been sold. And then there's the income. How much have you saved and how much using this technology, and so you do a present day value analysis, then you can find out the value of your company. So this slide kind of summarizes what I've been talking about, which is basically you need to do quick conversions at relatively good quality for your provisional. That's going to ultimately give you a cost saving when you take that particular provisional, convert that into a non-provisional. Now, all along the path, what you need to do is look at where these technology, where they're going, where are they being applied to, right? And so you need to consult with your professor and saying, hey, this technology is great in your present design, but where else could it be applied to? And learn that map in advance, because that's going to make your downstream job a lot easier. You won't have to be worrying about spinning off your startup because nobody cares about your patent. So, evidence of use, that's what I mean. You need to be using this to constantly try to prove your evidence of use at every stage along the way. Things need to be assessed and validated. You need to rock it. You need to say, okay, if I'm going to go at the, let's say, after I just file a non-provisional, and my target is company X, if I were to take this claim and go to that company, would they accept that, or would they push back? How would they push it back? We don't do this, we don't do that, right? So I think with a little bit of early planning, it's going to make your job a lot easier. So now you're saying, hey, I don't have time. I have 200 of these. How am I going to deal with that? So fortunate for you, AI is here, and I think with a very simple, inexpensive tool, it can help guide you in the process. And then, of course, once you have a portfolio, what you have to do is then figure out how these portfolios interact and what's the value of them. And you can go through the various valuation methodologies that I've discussed. You can also talk to the companies early on and see what kind of objections they have. Because the earlier you talk to them, the more you're going to be able to fine-tune your patent claims. And even if it's, as long as you have a family in prosecution, you can still tweak your claim after they issue. So, even if you have made some mistakes along the way, there's still time to correct them as long as the application is pending in the patent office or a continuation thereof. So yeah, basically you need to assess your portfolio because that's expensive, right? You need to periodically prime the ones that prune the portfolio, prune the patents that aren't gonna make the cut. There's certain patents that, well, no matter how you do it, it's just not gonna be licensed, except maybe the only way to do that is to spin off the team as a startup. So you need a tool to evaluate the potential use of your particular patent portfolio. And I suggest that you consider AI tools to do this because human-wise, it's just very, very hard to do it. So one of the companies we invested in was called Power Patent, and it does this, and we're going to give you a little quick demo on the technology. The videos, I will provide the link so that after the call, you can go and look at the video yourself. But the essence of that is you need to transform the professor's idea into revenue much earlier in the process. Don't wait until the patent issues, and then you start trying to figure out who's going to license this, because by then it's too late. So I'm going to run into the demo next, but before I dive into the demo, any particular questions from the group? All right. So let's go to this particular technology. So what we'll do is I'll show you the tool where you can, from a professor's disclosure. So let's say, this morning I went to ArchiveX and arbitrarily selected an AI paper. So let's assume that this is a paper from your professors. It'll be something like this, right? So references. So what we do is we go to here, we go to invention disclosure, and we drag and drop that particular PDF in, and we ask it to draft. And what they'll do is they'll start asking you, do you want method or apparatus? And since this is an AI base, it probably doesn't make sense to do an apparatus. And it will run. And so as you see, it'll start generating the claims for you to review and extract the figures for you. You can pretty much just run that standalone and file a provisional with the output of that and attaching your professor's paper. So because it's going to be no worse, right? Most universities that I know of, they basically just do the provisional on the publication. Right? So here, so it's generating a set of claim for you automatically. And let me see. And here's the drawing that is extracted out of the paper, and that came out of this paper here. So you see the drawing. So those are the drawings that came out of the paper. And then what you can do is you can ask it, because it's a method claim, to generate a flowchart. And you can also ask it to generate drawings if you want to, but we don't need to. So click on Draft Application, and boom, in about 5 minutes, you're going to get a non-provisional set of, an application with a set of method claims and then all the figures from the paper. So this is a quick example of how you can just jump off from the professor's paper and turn that into a provisional application with reasonable quality that at the end of the 1 year period, you can ask your outside counsel to then take it and prune it and improve on it. And my guess is your outside counsel is going to be using another AI to improve on it, but that's fine. There's nothing wrong with using AI as long as you use it responsibly and you make sure that you have the professor proof it, you have the lawyers review it, and then after this, I'm going to show you yet another tool on how we can then take the claim that was generated and then try to infer commercial use out of it. So let it run. Let's go to this tool set. So this tool set here basically is you can create a claim chart. Let's say I'm just going to arbitrarily put in patent number 8 million. It's going to take a little time to run. Yeah. Okay, so this is the claim it retrieves from the issue patent, but you can always paste your own claim into it. And you can ask it to generate a claim chart. Yeah, so this is using AI, and it's now doing the research for the claim chart for you. So you can always ask it to target a specific company and do a claim chart for that. And it'll tell you where it's missing element, right? And so based on the missing element, either you can find your own knowledge of that, or two, the other option is to provide that feedback to the lawyer saying, hey, we don't have clear evidence of infringement because we're missing these elements here. So can we somehow amend the claim to get rid of those elements that we can't have, that we don't have clear proof of infringement, right? So let's see what it's doing right now. Yeah, it's doing it right now. So this is for one of the things, and so you see it's now adding, and it's basically telling you that where there's a gap, right? So what I'm suggesting is that you use these tools very early on during at the provisional stage, at the non-provisional stage, and during prosecution, whenever you get a rejection from the patent office, you use that chance to change, because now you know where your target is. We recently ran across a case where, it was a one-on-one rejection on a software AI invention, and the patent office, the new director, recently provided a direction where if you put in they call it a SMED, a subject matter eligibility declaration, a SMED. So I tested that. We said, well, the new director says, hey, you supply a SMED and that can overcome the 101. So there was a case on final, and so we decided to go ahead and take our chance, risk, and went ahead and went appeal. Well, it came back last week, and it was completely, they basically, they agreed with the examiner. So I look at it and I said, well, what do we do with this? Do we keep on fighting the case, or let me run first through this tool what the claim coverage was. Well, I found out through the tool the claim sucks. So I said, well, okay, no loss. We went on appeal, we lost, we went down. But that's okay. We will now retake the same disclosure and run this tool through, and now we crafted a brand new set of claims that are much more valuable. I just saved myself a ton of money, or the startup, a ton of money, and now increase that yield. Because that thing was filed 2 years ago before we had these tools, and the claim at the time looked reasonable, but we were operating blind. We were flying blind, not knowing what the commercial coverage was. With this tool, when I saw that, I said, hey, we went to appeal and we lost, but hey, we won. Because we filed a continuation, we redid a new claim, and now it reads on the industry leader. So a loss is a win in that sense. So you'll see it here, that it does a very good industry mapping like that. So that's how we use that. Let's go back to the patent application. Let's see how it's done. Oh, it's still working, jeez. It takes a little time to draft, but it's going to be about 30 to 40 pages when it's done. Let's see when it's running. But while it's doing that, any questions on the tactics and this is a way for you, where I learn from you guys. You're experts at licensing. I'm just a patent lawyer and an investor. So I'm sure there are things we can improve on. So please do. Yes.
How did you train the patent drafting?
That's a tool that was done by Power Patent. So originally, that company, we invested them during the COVID era. They were the first to play in using open source GPT-2. And yes, back then, we had racks and racks of GPUs running training. But GPT-2, we found out that it was trained on the patent database. But even there, the way it generates the text is kind of crude. So what Power Patent did then was, eventually GPT-3 and GPT-4 came out, and they were much better at putting the language together. So what we did was we used a combination of the patent stuff that we have that we've trained, and we use GPT-5 now in the front end to generate that. So that's the process of training. But these days with the large language model, I don't think anybody needs to train anymore. It's that's pretty good. Now what Power Patent did was there were users who in the 5G space, and they says, hey, I want them to use my prior applications as the model to create the new application. So yes, it uses a RAG to learn from those and then spit out new applications in that particular format. So in a way, the training is there, but it's more customized to the technology. It's not so much generic training anymore. Hope that makes sense. Yes?
I have some questions on the claim charting. So from what sources are you pulling that data? Is it spec sheets? Is it from the company's websites? Forward citations from patents? Where is the source of that?
It's from searching the internet. So what we did was we start a bunch of little searches. We spin it off, and then we retrieve those results, and then we bring it back to the main LLM, and then it starts the charting operation. So it does a web search. It will look for products that most matches these claims. It will bring it back, and then it will do more repetitive searches. So it's an iterative process.
So on that iteration, when it identifies a product and it's doing a claim search, it's ensuring that its claim mapping is to a single product or method, not crossing across methodologies or across patent products.
Yeah, that's right. Because you'll see here the claim language is on the left side, and there's sources here that you can go verify yourself.
Okay. But yeah, I mean, and my concern is being that it doesn't pull like one element from one product and another element from a separate product.
No. I mean, that's not the way claim charts are done.
No, that's what I mean.
Yes. I'm sorry, go ahead.
How does it work if there's multiple inventions, especially if they're unrelated, like a new therapeutic and a new animal model?
You just have to do one for each. It does accept a cluster or a patent, so you can have a CSV file and upload them in, but that process is going to take a long time. So I wouldn't suggest you sit, you watch it. So just upload it and then come back whenever it tells you when it's done. Yes, sir.
Is it also utilizing like the PTO database to find patents, or is it strictly spec sheets from company products per
Strictly from the product, you know, the value of the PTO is, I guess, the backlink count. But you know, we find that backlinks are more valuable for the value of the patent. But it's rare that because there's a backlink that there's infringement. So it relies more on the actual product. And I think that's the way a real claim chart is done. You're not going to do a claim chart from looking at a backlink. So, yes?
So are you utilizing foundational models?
Yes. We use a combination. We use a bunch of different models. We use GPT-5, we use DeepMind, we use Claude. And so the beauty of these is the more you use, the different perspectives you get, right? So what you do is, and I've done this, once I get this output, I run in and I'll say, you are a lawyer representing, you know, let's say an infringing company. Argue why I don't infringe. And then it comes back, and then you iterate that. So the beauty of the LLM is that you can give it different personalities. You can say, let's say hypothetically I'm in the software space and you know, maybe the big guys in the space would be Google, Facebook, IBM, Apple, let's say, the usual suspects, right? So you'll say, you are a patent lawyer for Apple. How would you respond to this claim set? And then you do the same exercise, go down the list, and then when you look at it, it'll inform you a lot because you know, some of it may be wrong, some of the LLM may be wrong, but you learn a lot from playing the personas of the you know, of the company. Saying, hey, you are IBM. Looking at this patent, why should you avoid? Why should you not take a license?
So because you're using the foundational model, is it okay to also assume that you're enriching your data set with some sort of retrieval?
These are public information. There's no harm.
So then if it's public information, so why would not anybody just go and use Claude, for example?
Oh, yeah, you can't. But in my experience is that these softwares incorporate a lot of heuristics in there to make it better. So, but yeah, you can walk down the exhibit hall and ask those vendors, why can't I just use Claude to write a patent application? Why do I need you?
Yeah, okay. I was just curious.
Yeah, no, you can always do all this by yourself, but that's almost like building your own tool, and at a certain point, you can't compete against 100 programmers attacking it, you know. So, yes, you're right. You can always do it by yourself. Yes, sir.
Yeah. Is there any fear of putting non-public information from these manuscripts, provisional, into these databases, into the GPT-5 and the databases?
Well, yeah. If you use an open, you know, a free version of GPT-5, I would not suggest doing that. I would suggest that you would go and do a paid version, or you would use these specialized software because they, you know, they conform to SOC 2 compliance and confidentiality issues and things like that. So I would not recommend using the free ChatGPT version to do what you're doing. Yes, ma'am?
Is this model also, like the data that you put in there, is it also being used to train your model to write other people's provisionals or draft them?
No, it's really more of a one-way exit out. What they do is you give them the claim, and then it'll go and it'll search, but there's no value for it to learn from what that particular search is. Yes, ma'am?
So the claim chart of mapping currently existing possible infringement.
Yes.
Is it able to speculate any future possible likely infringement as well, so you can kind of further share your claims?
We've done that, but it's not very, you know, you can't really rely on it. You can, you know, there is a prompt set that says, study all the press releases of future direction of this particular company and map that into this thing. But that's just a prospective statement, so that's really not a claim chart proofing so much, right? But the interesting thing is, if you look at this here, there's a huge gap in this particular patent, number 8 million, that I just randomly use as an example here, right? So this is an issued patent I just randomly picked 8 million just because it's a round number. But this particular patent has a problem, is none of this particular element here is a gap. Everything else is. So if I were them, you know, if the case is still pending, I would basically try to get rid of that element during prosecution and then try to shift it to something else, because that patent right now is not, doesn't have a lot of value. Yes, sir?
So you uploaded an academic paper. An academic paper you generated this from, is it?
Oh, no, that's that's two different things. So we uploaded in the demo here, we uploaded I was talking about creating a portfolio inexpensively and early on. So in this part, I wonder if this machine has Word that we can look at it. But if not, we can look at the output. But basically, it generates a non-provisional application. And what we were suggesting that the community do is use AI to generate a non-provisional application, attach your professor's paper into that, and file it as a provisional.
But would that not invalidate, or we can patent application, publish paper?
Would it, what? We can?
We can the application.
How can it be? It's no worse than if you just take, most universities, they just take the provisional and file it.
Yeah.
I mean, not the provisional, the paper, the professor's paper.
Yeah, from a disclosure point of view, it's been disclosed.
Well, you're filing a non-provisional, so it's secret. It's no different than your existing process, right? Your existing process is to take the paper, file it as a provisional. Now what I'm suggesting is use AI to create a non-provisional, stack your paper into it, and file it. So here, you can see that it's generated its patent application. Let's see, 48 pages in about 5 minutes, right? It basically took the publication and created that for you. So, and it generated a claim. Let's look at the claim. A method for agentic uncertainty qualification from an agent. So yeah, from this paper, we generated a claim that looks very reasonable, right? And the question, and the next step is you take this and then you run it through a future infringement analysis to see if the claim should be tweaked, right? So, so here are the claims, generated 12 claims, abstract, generated the figures for you automatically. I wonder what happened to figure 1. Oh, that's at the end, probably. The flow chart is going to be at the end. It generated a flow chart for you. Yeah, there it is. So it added one more bit of information from the professor's paper by adding in a flow chart based on the claims that was generated. So now you have, you know, what you have now when you file it is an application that has almost a high quality non-provisional, subject to review by outside counsel, of course. Or if you're experienced enough at that, you know, we talked to a lot of university tech transfer that are very seasoned in terms of patent filing, and they can just review it and file it themselves, save the university a ton of money. Right? And the objective here is, I think, to have higher quality that is infringible and costly. So that is the non-provisional that was generated from this particular paper, and it took about, I think, 10 minutes. So it extracted out all these drawings automatically for you and put it into a format that outside counsel later could use to clean up. And then I think, you know, in our experience with the startups, they ask outside counsel for a discount because, you know, normally outside counsel does everything from scratch. Now what you have is that they have a first draft that is, yeah, you know, maybe a B or a C grade. They can go and tweak it up, and they can certainly use you know, their own AIs to add their own perspective. And that's the whole point of a lawyer. You're not hiring a lawyer to be a technical writer, right? I mean, so when I came out with a patent that says you cannot do more than 3 retainers that are sequenced, that's the value of a lawyer. The lawyer has to look at it outside of the technology that's there. Because if we went down a technological path of an Invisalign where they really were focusing on 3D printing, on CAD, on what else? And CAD, 3D printing, yeah, intraoral scanning, right? We would have missed that patent that held the industry at bay for 20 years, which is the patent that says you cannot have more than 3 retainers in a sequence. That ultimately maybe what Invisalign is. It's not the 3D printing technology. It's not the CAD technology. That's the value of outside counsel, is to bring in that independent review of the case and to add the value onto it. And that a machine will never replace. So that's kind of the hypothesis that we use at my firm. So you'll see it here. Let's see. Yeah, and then they provide contact information, right? So of course, the easy thing is to go for LinkedIn, but it also, in some cases, it can identify even phone numbers that you can call. So, this is a tool that's going to help make your life a little bit easier, I hope. Yes, ma'am?
Yeah, as a patent attorney, if I provide you with the AI draft like this, how do you think about it? Because as a tech transfer office, we have sometimes I have professors like to write, and they send a full-fledged drafted patent application. My outside counsel actually hates it. They don't give me discount if they receive that.
Well, you should fire the outside counsel. I love those things. Look, all the outside counsel does is, I think, that particular firm, that's just being a technical writer. That's not the value of a patent lawyer. A patent lawyer's value is to look at the claims and then suggest how you might alternatively look at this, right? If you're just paying a lawyer just to be a scribe and you've given him the technical document, guess who's a better technical writer? The professor, or you think outside counsel? So that to me is it's just a case of self-serve, so of course they hate it because the fees are the job, but your job, you don't care. You're trying to maximize the value of what you got. Yes, sir.
I mean, to build on that question, because I do think it's a legitimate point. We have in-house counsel as well, and they're very reluctant to use a tool such as this. How would you convince them that it's actually helpful and not hurting?
Well, I mean, I can rely on just a statement. The difference between the person who uses AI and the person who doesn't is the guy who uses AI will have a job.
Yeah, but do you have any data? Because I mean, that's the message that's always passed along. That's the answer we all give, right?
Mm-hmm.
But do you have data on how this works?
I think the bottom line is. We have data, but that's not directly answering that question. We have about 150 patents that issued written by AI. About a year ago, that was, and I can see why the industry is behind, because a year ago the patent office was saying, well, you might be able to use AI tools, but you have to document, which contribution is a machine, which one is human. That was about a year and a half ago. So probably the industry is somewhat reluctant because now you have to say, well, this came from machine, this came from us. It's a lot of extra hard work. The new patent commissioner came in and he said, yeah, AI is fine. So he's, very much, I think, losing that restriction. And so the key to me, when you're looking at this, is not so much who generated the text. It's no different than an SEO blog, right? The marketing industry has been rocked because AI now is writing everything, right? The problem is not so much who writes it. The issue to look on is the content valuable to you, to the reader? So it's irrelevant on who generated this. And so the key is for you to use the machine output and then edit them and apply human review and strategy and thinking outside of the box. That the machine doesn't have. The machine, all it does is you're telling it, here's a sequence of information. I will comply to that sequence of information. But it can never, ever do a claim that says you cannot do 3 or more retainers in sequence because that's outside of the box. That is the human value that I think lawyers are, and practically everybody else should be focusing on. We shouldn't be saying AI is not useful. We should say it's useful, but it's under our control. All right, any other questions? Or yes, sir.
So how many patents do you file that don't get any review from inventors or from counsel before you file?
Sorry, could you speak a little louder?
If you're using this AI tool, what percentage are filed without some sort of human intervention to review?
Well, the process is now started, they use this software, and then they send it to me to file. And so when I file, I review them too. So we recommend that you work with lawyers. They are important. It's just that it is the task of the lawyer being a technical writer. No, the part of the lawyer should be is looking at the claims and seeing how they might best navigate through unknown prior art or infringement. That's a very hard thing to straddle. So that's where lawyers should be focusing their attention on in the age of AI, not to be a technical writer, because that doesn't add a whole lot of value. So you should be reviewed by, I think, did I answer your question?
You did. I was just curious as to how many of these are being pushed the button to send.
I don't recommend that. I don't think anybody would.
Good.
Yes, are there any existing university technology transfer offices are already using the system?
We have not been targeting, we've not been talking to university transfer yet. It's really used in the portfolio companies that we work with. So this is the first time I've presented the use of this. And in fact, Power Patent is one of our own portfolio companies. So, you know, I'm a little bit biased, but. All right, yes sir?
So going back to uploading unpublished manuscripts into this, if I do that, does it not count as a public disclosure?
No, this is, you're under a contract under, you know, to a vendor. So how is that any different than you're using Word to edit your thing? Is that a public disclosure? No, you're buying a service, right? So that's why I said you don't use the commercial free ChatGPT. If you're going to use the tool at all, use the paid version, because it has the applicable security and privacy and SOC 2 compliance aspects to it.
So did I also hear you say that with this tool, that you're bypassing provisional application and going straight to the non-provisional?
You can, if you want to. We recommend that for AI software companies because the Q2 examination is about 2.5 years. So if you use a provisional, you're now talking 3.5 years before you get examined, and then another at least 6 to 9 months to issue. So you're talking about 4 or 5 years. And in the AI space, 4 and 5 years, a lot of things can change. So now, for medical, that's the right way to go. I mean, you know, obviously the pharmaceutical companies are expert at this. They file full non-provisional so that they gain an extra year of life. They want that. But I think in certain technologies that are fast-moving, like AI and robotics, things like that, I would counsel the startups that we work with to go in and go fast. If anything, expedite the prosecution. There's a lady behind you, so I'll talk to her first, and then I'll go back to you.
I'm just curious, are you finding that IP boutique firms or IP firms in big law are adopting these types of technologies themselves? Because you said you would run it and then you bring it to your external counsel, but I wondered if external counsel would have its own services that it's adopted and it prefers to use.
My sense is that most law firms are experimenting with it. I don't find adoption because significant adoption. I mean, you can talk to DeepIP out here or Solve Intelligence. They each have raised about $50 million. So when you raise that much, that implies that you must have some customer base, right? But my private sense in talking to people, they're still suspicious of the AI generated text. And on top of that, I think there's another reason why they might want to drag their feet. The reason is, you have to disclose you're using AI to the client, right? And when you disclose you're using AI to the client, your hours now shrink from 20 hours per case down to maybe 2 or 3 hours. They're slashing their own throat. So that's probably one reason when you're seeing that. But I think what you're seeing is there's a shift toward fixed fee prosecution. And that may alleviate this fear. It may be, you might reduce the cost down to maybe, I don't know, some proportion. But now it allows outside counsel to freely talk to you. Say, hey, we use these tools. It improves our efficiency. We're going to pass part of it to you, but you know, we still want to do well. So it's going to be a structured negotiation, I think. All right, back to you, sir.
My apologies for hogging the conversation, but you showed one manuscript being used. What if you have scenarios where you have multiple? You know, I have inventors who are going to provide me with 2, 3, 4, 5. Different type manuscripts. So what happens when you put them all in that soup?
It should improve it. The more information you give it, the better it is. So you can just consolidate into a big giant PDF and upload it. All right, gentlemen, way behind it.
So, I know I'm outside counsel, and so I want to push back on this lawyers shouldn't be technical writers thing. And sort of a question of, how many of these have you actually gotten to grant?
Oh.
My feeling is when we draft, the claims are great in the beginning, and maybe if we could write something narrow for those claims, fine. But most often, our clients and us don't know everything's out there. And so our goal with writing the spec is, we need it to be broad. We want to be able to make claims that can be amended to meet the art that's going to be raised by the examiner down the road. And we've tried lots of these AI softwares, and we've found they're quite good at drafting narrow to what we think is important at the outset. But we haven't found ones that are good at allowing us to pivot down the road.
Yeah.
I was curious what your finding is on how, 3 years down the road, are you getting, and the examiner raises prior art that you didn't know about, do you have a spec that you're able to pivot to meet that?
Well, let me show you the, I guess the output. I think we closed the window, right? But, oh, no, it's here. So you see that in about 10 minutes it generated 50 pages. I posited that most outside counsels, they average about 30 to 40 pages in length. I routinely do 200, 300 pages with AI because it's so cheap to do. And so when we do that, what we do is we take the claims and then we chop it multiple ways, like what we discussed, which is taking here's a claim, here's potential infringement analysis, and if you don't have it, then you do a different variation of that. You throw all those variations into the claim. So you can do it like this. Let me see. Okay, so what you can do is this. You can go to the claim section. You can paste in, let's see. Yep, this is one set. Right? This is one claim. And so it generated 48 pages from one claim. Okay? And then what you do is you add claim set, and then you can do variations more of that. You can do, I'm doing this on the fly, so. So what I'm saying is that you can do multiple hypotheses of variations of this particular technology. And because you're able to do 4 or 5 different claim sets that you generated, those claim sets are very controlled and very high quality, right? When you feed that claim set into here, it's going to generate routinely 150, 200 pages. I, in fact, had a case, a robotic case we filed 2 weeks ago, 750 pages in length. And I look at it, and then the extra page count was going to kill us. So so I looked around and said, well, shoot, what are we going to do with this? So what we did was we basically shrunk it down to very small font and double columns, and then you file them as a provisional, because that would never fly if you file as a non-provisional, right? So that reduced it down to 500 pages. And guess what? Even on a small entity, that was going to cost us $1,000 in PTO fee. But what it did was it preserved a 700-page in spec, right? And then what we did was then we took one of those sets, the claim set that we crafted, we pull it out, and then we had a human to go through and then review the text that would support those particular claims and shrunk it down to 150 pages. And that's only because this is the first time I've done a 750-page patent application, but I think I'm going to ask the Power Patent to do a way where I can shrink down page count. So that what we do is we claim priority to the provisional, so we preserve those 750 pages. We do the non-provisional as 150 page, and guarantee you, examiners aren't going to read this. What they're going to do is they're going to read the claim, and they're going to very mechanically go through and find prior art to try to piece it through. They're not going to bother reading the claim for support. Not 700 pages. So that's the way we have support and flexibility for future growth. Because yes, you're right. I believe less than in prior art search, because for $500, what are you going to do? You can't go and search Russia. You can't search China or Japan. All you can do is probably do a U.S. search, and you can't even find non-published applications, right? So no matter how much you spend on a prior art search, it's just not worth it to me. So I subscribe to your philosophy, which is a very deep, long disclosure, and the AI amplifies that ability to do that very cheaply. Hopefully that answers your question. Yes, sir.
Can you talk about your thoughts when you file provisional and you're anticipating maybe filing in Europe with less flexibility on changing these claims? And do you trust the AI tools to put forward claims that you can then use in the prosecuting?
Well, we did a case recently where we used not Power Patent tool, but we used a tool called, I forgot what it was, AI language. It was a translation software, and it cost about $100, I think. No, if you buy an annual subscription, it was like maybe $200. And so I bought it. I had a trial for that, and I bought it. And when I took one of those, the 150-page cases, and I converted it to German, converted it to Brazil, to Chinese, and then Vietnam. Why is Vietnam? Vietnam is now the place for manufacturing, so that's why you want to go there. So, and I was converting it with a sense of dread, because I know that all these international councils, they live off from the translation fees, right? So let's see what they say. I sent it to the German guy, he looked at it and said, that looks good to me, I'll file it. Sent it to the Brazilian guy, he accelerated that, because in Brazilian you can accelerate. So the AI translation of the English into other languages are very, very good these days. I was shocked that outside law firms in Brazil and German, they look at it and they said, yeah, it's fine. And then I checked with the Vietnamese counsel, and it took them 3 months. But basically I saw the revisions coming back at very minimal. So, you know, I think that the days of international law firm making money from translation, that's over.
Well, I was thinking less translation and more, you know, the idea is to file these provisionals using AI, you know, maybe it's a little bit lower quality potentially, but then, you know, it saves you money. But then in Europe, you really kind of need to get the claims at least somewhat kind of right at the provisional stage before you go into Europe. So I was just thinking your thoughts.
I think what you need to do there is, if you're planning on going international up front, then work with outside counsel early. You're gonna say, hey, here's my proposed English claim. I'm using AI to convert that into an EP claim format. What do you think? So you need to work with them, because no AI is gonna replace a human. I think it's an accelerator for lawyers, but you still need you know, good local counsel to advise you along the step. Any else? All right, sounds like I'm done. What time is it? Wow, 12. Ah, okay, we have 15 minutes extra left. So, well, great. I think, you know, hopefully it makes sense. And yes, sir.
Okay, so say you have a portfolio of academic research. Okay. None of it is being submitted for patent. How would you use this tool to identify the best candidates for patent applications and licensing?
I think what you do is, this tool doesn't support that capability yet. I think what, you know, that's a very interesting point. I think what I'll suggest to them, to Bao Tran, is now to bring in a portfolio of, let's say, papers from professors, generate a set of proposed claims, right, and then run this through the claim mapping analysis. And then you can, and then from those papers, you can then figure out which one you're going to drop. You're not going to file every single paper, right? So that doesn't exist at present, but I think what you're suggesting makes a lot of sense.
If you 500 academic papers, what would be really, really useful is what you just said, the ability to really put all of them in, screen them, and rank them on their commercial viability.
Absolutely. I think that doesn't exist right now, but that's an excellent suggestion.
There's an idea for it. There's a patent for it.
Sorry?
There's a patent idea for it.
Ah, yes, yes.
I said it first.
Well, all right. I think we're done early. Thank you so much for coming. You can, you know, feel free to connect to me at bao@tran.vc. So look forward to, you know, enjoying the rest of the conference. Thank you.